day 5 of 7 days online National Faculty Development Program on Emerging Trends in Intellectual Property Rights, organized by Vimla College Autonomous Thrissur in collaboration with the Inter-University Center for IPR Studies, Cochin University of Science and Technology, RVS College of Arts and Science, Coimbatore, and PSGR Krishnamal College for Women, Coimbatore. Now, let's begin the session by invoking the blessings of Almighty with a silent prayer. Now, I invite Dr. Gigi Abraham, Assistant Professor, Department of Chemistry, Vimla College Autonomous Thrissur, to introduce the resource person. Over to you, ma'am.
A warm good evening to one and all present here. Myself, Dr. Gigi Abraham, Assistant Professor, Department of Chemistry, Vimala College. Once again, welcome you all to the 5th day of Faculty Development Program on Emerging Trends in Intellectual Property Rights. It's a great pleasure for me to introduce our speaker, Dr. Vishnu Shankar P, who is going to talk us about the topic protection of trademark. Today, we have the privilege of being in the presence of a true visionary in the field of intellectual property rights. Dr. Vishnu Shankar P completed his LLB from School of Legal Studies, CUSAT, in the year 2012, LLM with the first rank from the Inter-University Center for IPR Studies, IUCIPRS, CUSAT, in the year 2015, and was awarded PhD in law from Inter-University Center for IPR Studies in the year 2020. Formerly a research officer at the IUCIRPS, Mr. Shankar was involved in academic teaching since 2016 during the early stages of his doctoral studies. He is the recipient of gold medal for the best research paper on IPR instituted by Inter-University Center for IPR Studies, CUSAT, in 2016, and has significant academic publications to his credit. Since 2021, he is a recognized research supervisor at CUSAT and has 7 doctoral scholars under his supervision. He has successfully supervised 10 postgraduates in completing their LLM dissertations since 2020. Additionally, he acts as a resource person to various national international seminars, conferences, and workshops. Ladies and gentlemen, please finally join me in giving a warm welcome to our resource person, Dr. Vishnu Shankar, for handling the session of protection of trademark. Welcome you, sir.
Thank you, ma'am. Thank you all. Thank you. Thanks so much. Thanks so much. So, shall I begin then the session?
Okay, sir.
Thank you. Thank you. First of all, thank you. And I apologize for the delay that was caused. I had an urgent meeting with the VC. That's why I was held up in the meeting. That's why I was late by 5 minutes. Thank you for giving me the opportunity to speak on IPR and trademarks. And I hope both languages, English and Malayalam, is fine, right? So I will be switching on to Malayalam and English in between. And am I audible and visible?
Yes, sir. Audible.
Okay.
Yeah.
So the last four days, you would have definitely heard about IPRs, and you have bombarded with the concepts of IPR. So today we have a different session on trademarks. Usually, how I handle my session, let me caution you in the beginning itself. I'm not somebody who depends morely on slides or etc. etc. I'm somebody who actually love to interact with the students and as well as faculties, so that there is exchange of ideas. So I don't want anybody to keep mum in my class. Please ask questions. Stop me at anywhere if you want me to stop. And please ask me questions. Please interact. I would be raising questions, practical questions, not on law or any IPR questions. I like to handle my classes in a realistic manner, giving you examples that you have seen in your classes, in your life, in your day-to-day lives. That's much interesting rather than me lecturing on IPR, which will be very boring, I'm sure, especially when it is 7 o'clock in the evening. So I do have a slide. I do have a slide with me, but I tell you, I will handle it in a very personal manner, very in different manner. So I'll present it right now. I'll just present my screen.
Yes, sir. Excuse me, sir. Many of the participants are outside Kerala, so I know they don't
No
know
issues.
Malayalam. Okay, sir.
No issues. No issues. No
Yeah.
issues. Thank you. Thank you for that. Is my screen visible right now? Has it come on screen?
Yeah, yes, it is visible, sir, but it is not in the slideshow mode.
Sure. I'll make it. I'll make it share screen. Now I think it's fine.
Not in slideshow mode, sir.
I have changed it to slide mode.
Yeah,
It's not yet. It's not in slide mode. It's not visible in slide mode.
I'm not getting, sir.
Actually, I had changed into slide mode.
Yeah, sir, please present the full screen, sir.
Just 1 second.
Yeah.
I think I can't present my whole screen.
Sir, please present entire screen, sir. Entire screen.
No, I did. I'm trying, but it's not working. In fact,
Okay.
yeah, that share button is not working in my. I don't know what happened. Might be a strength. Is it fine if I present it like this?
No problem, sir.
Okay. Maybe a net issue, I believe. Yeah. If this is fine, then can I proceed with this? This is fine.
Okay, sir. Proceed.
Sure. Okay. So trademarks. Basically, you would have seen copyright, patents, and all those contexts. There are different forms of IPR. Now, the first thing that I want to convey is that every IP has its own philosophy. So, the philosophy that is working on copyright, as you would have seen, is not. It's like you have a copyright for a book, for a film. You have a patent for a medicine. These are things which actually have a very strong connection to your life. If I put it in another manner, they are very essential for your life. Because books, you need it for access to knowledge. Patents, you need it for medicines. But trademarks, I might not call it as essential stuff. So can somebody tell me their basic idea of trademarks? What do you have in mind when the first name trademarks comes in your mind? What exactly do you have in mind? Do you have any idea? Anyone, please. Any vague idea of trademarks? Please come on.
It is just a protection, sir.
For what?
Protection of their property.
Of property,
Like-
trademarks of what property? Maybe.
Property means if mostly they claim for industrial purpose or commercial purpose.
Right, on IPR. I'm talking about trademarks. Can you have any link? What is trademarks? Trademark has no commercial purpose, right? So you have seen trademarks, right, in your life?
Yeah,
Can you
that is.
Can you give examples?
Most it's the commercials. A trademark is where we can find any commercial aspects there, and the logos are there with the trademark symbol and all.
Okay.
Sir, for identifying a product in the market.
Good. Thank you. One answer is commercial. Second is identifying the product. Okay. Anything else?
Sir, it helps to advertise the product, sir.
It helps to advertise the product. Okay. Fine. Good. Any more? Fine. Thank you. I'm so happy. I got 3 points. 1, commercial. Second, identifying the product. Third, advertising. So that's a good starting point. But nobody said about the aspect of consumer. In fact, trademarks has a strong connection with the consumer. In fact, trademarks works on the principle of consumer. I'll tell you how. So before I begin, I want to give a background of how IPR works, because if the background is not given, you will not understand how trademark is going to work. So IPR, I'll quickly run through these things. IPR came into picture as a reason for providing access and affordability. I'll give you a story for that. The first in England, when in old times in England, some people came to England from France and claimed that we have a new thing in our hand and we want to commercialize it in your country. So Queen thought about it and debated about it. Later, she called up these people and said that, okay, I will allow you to commercialize these things, but you need to satisfy 3 conditions which I am going to put forward. 1, you will have to teach my people your new invention or new thing that you have found out. Second, you need to make it accessible to my consumers. Third, you need to make it accessible in a reasonable price. So 3 conditions. 1, teach my people. Second, make it accessible. Third, make it accessible in an affordable manner. This was a starting point of IPR, or let me say patents. So they came to that country. So they started to teach people. So when they started to teach people, what happened was that if I am the person who has invented it from France, came to England, commercialized it, taught people, maybe I taught a guy called as, say, Ravi. I taught him how to make it. You know what Ravi did? He made it and said that Ravi's product. In fact, that was whose product? It was my product, Vishnu's product. But unfortunately, I only had the invention. I did not have Vishnu's invention. I only had patents. It was my invention, true, but no name subscribed. So they thought about it. Okay, I have an invention. It is innovative. I can share it. Good, well and good. But my name is not there. So you know what they did? They had something called as inscribing they heat the metal and they inscribe on their invention, their name. In those times, it was called as guild system. And that guild system usually had community's name on it. It was not a person's name, a community's name. So that community's name was ascribed on that invention. That was the starting point of trademarks, to identify whose product is it. There could be an invention, but whose product? That was a tricky point. Even though it was not called as trademarks, but still a logo, a name, a mark came into picture. That is why in history of IPR, I have told about access and affordability, transfer of technology, local working. All these things were there. For that, they also had trademarks coming into picture, my name into it, so that they identify whose product it is. So this is how trademark came into picture. Moving on, this you might have seen in your previous classes, so I'm not going into those things. Before I go to standards, I'll come back to the slide. But before that slide, I want to talk about trademarks. Now, trademark is defined in section Z clause B of the Trademarks Act 1999. That definition is very important. What is a trademark? I have not put the definition in this slide so that it need not be boring for you. One student had actually, one student of faculty had in fact told me that it is a logo. But it is not just logo. You have different concepts within a trademark. I will read out the definition and then I will explain. The definition goes like this. A mark means, trademark means a mark capable of being graphically represented and which is capable of distinguishing the goods or services of one person from those of others. I'll repeat. Section ZB defines trademarks as a mark capable of being represented graphically. I'll stop there. So trademarks is primarily a mark which is capable of being represented graphically. So being represented graphically means it should be perceivable. We should be able to see it. No mark can be protected under this definition if it is not being able to be graphically represented. Let's take the example of a famous trademark, say KFC, KFC. It has been represented graphically. How? K is there, F is there, C is there. So when I claim a trademark, what I do is that I go to the trademark office, which grants me protection. I go to the trademark office, I draw my K, I draw my F, I draw my C. I also give it a color, red color, green color, whatever color, white color, mixture of red and white, whatever it is. So I represent it graphically. Now, why is it this important? Is the protection granted to K, the letters K, Letters F, letters C? No. The protection is granted for the combination of KFC graphically represented in a particular manner. The red color or red or white color combination in a particular font, in a particular manner, only for these three letters. So it is not the letter. The combination of colors, the combination of letters represented in a particular manner is the mark that is protected. That is the protection protected. It is not the letters. It is not the colors. It is not the combination. It is a combination of all these things that is being protected as trademarks. This is the first part. So it means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others, which is capable of distinguishing the goods or services of one person from other. So this trademarks has a function. What is a function? This trademark is capable to distinguish KFC, the holder of the owner of the trademark, KFC, is capable of distinguishing the product that has been sold by KFC from those of other chicken products that is sold by other persons. Why is this check there? Why is it meant that it should be capable of distinguishing? Can anybody answer this question? Why is this standard there in this definition that it should be capable of distinguishing the goods? And what would be the reason that the trademark should have a function to distinguish the goods? What could be the reason?
Otherwise, we cannot, if you cannot identify it, then even if somebody passes it off, or there is an offense of passing off, we wouldn't be able to claim any rights. If you cannot clearly or accurately make a link between the product and the trademark.
Okay. Good. Very good. Thank you. Exactly. We will be at a position not to distinguish between the product. For example, I go to a shop. I find KFC. I find KZC. I find AFC. All written in the same manner. So I might be confused as to which one is which. And at this point, let me clarify something. Trademark does not mean that product is a very good quality product. Trademark does not assure that the product is very good. There is no assurance. Trademark only means that the mark indicates certain quality. I repeat, certain quality. It could be good quality, it could be average quality, it could be bad quality. KFC might be a good quality. KZC indicates some quality. It might be good, it might be bad. But at least the consumer knows KFC means good, AZC means bad. But I am fine. Bad quality is fine. I want a product which is cheaper. Quality might be bad, no issues. I want cheaper. and cheaper is designated by AZZ. This is a function of trademarks, distinguishing the product. It does not assure a quality. I mean, good quality. It assures certain quality, which might be good, which might be average, which might be bad. So there is no assurance of good quality, but it indicates certain quality, right? So when the consumer goes to a shop, he understands, okay, I have a good quality, high priced, I'll buy it. I have a low quality, low price, I'll buy it. This is a function of trademarks. Now the definition goes on. The definition goes on to say that the mark can include not just logo, not just logo. It could be shape of goods. It could be shape of goods. Have you seen 7-Up, the bottle? It is not just 7-Up that is trademarked. The shape of that bottle is also trademarked. If you have seen that advertisements earlier, they used to depict a lady's shape of a lady. In fact, that bottle is designed in that manner, and that has been trademarked. So it is not just letters, it is not just logo, it is not just colors. It could be shape of goods. It could be packaging. It could be packaging. For example, I forgot that chocolate name that kids you have a chocolate like a shape of egg. It contains chocolate.
Kinder Joy, sir.
Kinder Joy, exactly. Yeah, thank you, Kinder Joy. Their claim was on the shape in which they have built it. They claim trademarks over that, or that, sorry, not shape, packaging, or that packaging. And there was an Apple group, an Apple selling group, who claimed trademarks over the way they pack their apple. It can be protected. So logos, letters in a particular manner, shape, packaging, and then comes combination of colors. It could be combination of colors. Certain colors mixed in a certain manner, which makes it unique. So these are subject matter. In the legal terms, we say that it is a subject matter. These are things that gets trademarks. Interestingly, for the last 5-6 years, we are seeing new kinds of trademarks. What I have just read out is the conventional trademarks. The latest development is non-conventional trademarks. And it is very interesting. Under the Indian Act, it is not recognized, but in foreign, they are recognizing certain other categories. It is called as smell marks, touch marks, visual marks, motion marks, sound marks. I'll repeat, smell mark. Well, I really don't know what is a smell mark, to be very frank with you. Because they say that certain food items, certain sprays have certain special odors, unique odors, odor in the smell, so that it can be protected. And they are granting, Europe is one country who's granting left and right smell marks. I don't know how it can be so distinguishing. Very frank, I don't find differences between the sprays. Might be my mistake, but I'm somebody who fails to differentiate smells. But in non-conventional trademarks, they grant trademark over a particular smell They grant trademarks over a particular taste. If my memory is correct, uh, McDonald's have a particular tea outside in US or Europe. They have a tea which has a unique taste, and they granted trademarks for that unique taste. They have granted trademarks for sound. Typical example is that roaring of a lion. Do you know what is which product it is? Roaring of a lion. Think like you know these things. Roaring of a lion. You have seen these things on TV. Linked to a cartoon. Roaring of a lion. Sorry?
Lion King. Lion King.
No.
Tom and Jerry.
Precisely. The Metro Goldwyn company, they have this roaring of lion with begin. They have given trademarks for that roaring. I am wondering how that lion in the wild are living, because a trademarking a roaring of a lion is the wildest thing I have ever heard. But they have given it. And currently in India, they are also trademarking personalities. Recently, Amitabh Bachchan got a trademark for his voice. I'm sad to hear it, but still they have granted trademarks. That is a new development that is happening. Trademark over personality. Trademark over the sound, shape. There's a famous case by Amir Khan, who in fact sued means went for a case against a barber in Kerala for depicting his picture in the barber shop. That poor guy, to run a business, depicted the photo of Amir Khan. And this Amir Khan, all the way from Bombay or Delhi, wherever he is, went for a case against this guy, saying that photo is my trademark. That face is my trademark. I have value. So these are the new developments that is happening. But unfortunately, the courts are granting rights, but the Trademark Act, does not recognize these things. For example, smell mark. How will you graphically represent a smell? As I read out, a trademark should be capable of being graphically represented. How will you depict a smell? Sound, I understand. Maybe you can depict by notations, high pitch, low pitch, that music that you have. You might be able to do. But smell, taste, I don't know. But unfortunately, Europe and US are granting, and Indian courts, with all due respect, are following the US or Europe style. So I don't know what is going to happen. Anyway, that is the latest development that is happening across the globe. So that is about trademark definition. So this is what trademark means. Now, before I go to other parts, my second bullet point is well-known trademark. A trademark, to get protection, should be registered under the Trademarks Act in India. That is the first criteria. You would have heard in the copyright class, for getting copyright in India, registration is not mandatory. It is automatic. A trademark is not automatic. You need registration for protection. But there is a category called as well-known trademarks. The so-called privileged, I always say this, privileged trademarks, well-known trademarks. They don't need protection. I'll give you examples. Somebody in the beginning, somebody had told me in the that trademark has a function of for advertising. But there are certain trademarks or some logos which you would have never seen an ad in your TV. Look at Maruti. Look at Hyundai. Look at all those common Skoda. All these companies have enough number of advertisements in the TV. But how many of you have seen the advertisement of BMW, of Benz? Is it that frequent in the TV? It might come up in some magazines. TV, at times it might come. But these trademarks we don't see often. They claim that we are a privileged group. We don't want these advertisements. We are happy we have it. Because we have reputation. We have reputation. I told you, for a trademark, you don't need a good reputation. You only need reputation. For well-known marks, you need good reputation. Good in the sense, not quality. Good in the sense, you are known to the public. BMW, we know it. We might not have it, but we know it. Well-known trademarks have a reputation, a good reputation, that allows it. It need not be it need not be registered. Even if it is not registered, you will get protection. And there's a very interesting case. It's by Benz. It is not. It's a case in 1970s. At that point of time, Benz was not registered in India. It was not a registered trademark. So what happened was that a poor chap from India came up with undergarments and he called it as Benz. And also, you know the logo of Benz. It's like a dot, then three shape like it's like this actually. Yeah. This guy did. He drew a shape of a man with two hands directed towards the top, two legs like this, two legs, a body, hand to the top, and a circle. Similar to Benz. So Benz went for a case. This guy said, come on, Benz is not registered. So what's the problem? And court said, no. Benz might not be registered, but Benz is a famous brand. And interestingly, the judge in the judgment said that even my father has a Benz. He said in judgment, even my father has a Benz. And in the judgment, he said that Benz is used by elite people. So tell me, do you think a trademark, a mark by a poor guy in an undergarment by the name Benz is actually infringing the mark of the car owner or car mark owner, Benz? Is that infringement? Will the consumer get confused going to a shop? Benz. Oh, so the guy who is producing the car is also producing a undergarment. Even if it is so, will you buy a Benz undergarment simply because the car by the name BMW is good? Will you buy? Will you get confused? I told you the function of trademark is to ensure that consumers are not confused. So will the consumer get confused? Tell me, what is your perception? Come on, please.
Here there is no confusion because they are two different products from different two fields.
Precisely.
But here it could be only protection of the goodwill of the company.
Okay, so if the undergarment is very bad, will you assume that the car is also bad?
No, but still many products which are even now in the market, there are many products with the same name. For example, there are certain jewelry companies which are having even garments. So we have this. Usually, the consumer sometimes equates to see whether it is the same company or not.
Right.
There are the number of branded companies are branded. Nowadays, we find a lot of
Correct.
products, different merchandising.
Correct. This is exactly the logic that the court used. Thank you, ma'am. Thank you. This is exactly the logic the court used. But I differ. I tell you, I completely differ from what the logic of the court. The trademark protection for a mark is not automatic. You have 45 classes or 47, if I forgot, 45, 47 classes of products in trademark rules. So if I register a trademark in one class of product, say restaurants, and I have a mark, I get protection only for that restaurant, which means that if somebody uses a mark, say for a gym, my same name, Vishnu's restaurant, somebody puts it as Vishnu's gym, I cannot sue him. Normally. But when it is BMW, you can sue because they are called as well-known, privileged trademarks. That is my problem. If it's a normal trademark, you have to register in every class to get protection. But if it's a well-known mark, I am sorry. Since you are well-known, you need not register. What logic is that? I don't understand the logic. So make it uniform. Whether it be any trademarks, you have one mark, you can use it for every product, like well-known trademarks, or vice versa. And I go with vice versa. If you want protection, please register in every class, or you will get protection only in the market you are there. For example, BMW car. Nobody can make a BMW car by your name. But undergarments, masala powder, paste, soap, come on. So well-known trademarks are those marks who have a reputation beyond borders. That is why it is called as trans-border reputation. So that is regarding trademarks and well-known trademarks. And the logic, I forgot to say this, the logic behind protecting well-known trademarks is called as dilution principle. Dilution principle. For example, there's a BMW car and BMW undergarment. Fine. Tomorrow comes up BMW masala powder. Tomorrow comes up BMW paste, BMW laptops, BMW computers, BMW books. That uniqueness of BMW mark gets diluted because others have used the same mark for different products. So tomorrow, when you hear the word BMW, BMW car or masala powder or paint, which one? That uniqueness of that mark gets diluted slowly. So to prohibit that, they protect well-known trademarks. That's the logic of well-known trademarks. Now coming to, am I running out of time? No, I think yeah. Now coming to section, there are some provisions within the Trademarks Act as well as other acts. For that, I'll just move on to another slide, previous slide. This is a basic framework of any IP law. You have a standard for getting an IP protection. The moment you get protection, you have rights. Then you have limitations and exceptions to that rights. Then infringement and enforcement. This is applicable to every kind of IP. Now, coming to trademarks, also you have the same thing. The first one, standards. You have a standard for getting trademarks. And that standard is enshrined in Section 9 of Trademarks Act, which talks about absolute grounds of refusal of trademarks. Assume for a moment, I have a trademark. I am building a trademark. Say V with a line with a mark across. So this is my so-called trademark that I have invented. I am going to the trademark office and I submit. Sir, I have a trademark. What is a trademark? It is a V, the circle with a cross. They will take it and they will check whether I am eligible for being protected under that mark. So you need standards for checking whether this mark is eligible for protection. So the first standard is lack of distinctiveness. A trademark or a mark, to become a trademark, it should be distinctive. Distinctive in the sense it should have some uniqueness. A simple letter V might not be sufficient. Anybody can use it. Or a simple, or let me say, a milk product. I have milk product. I have a picture of a cow in that milk product. That is my trademark. It's a distinctive. Anybody who is selling a milk product will have a cow in their logo, definitely. I can give you any example, any number of examples. There's a case in which a guy tried to trademark an eagle. That was trademarked. An eagle shape was trademarked for a product. It was a slide that is used by the ladies. So the company who is producing that slides had an eagle mark. That was trademarked, no issues. Now another guy came, claim for trademarks. That guy claimed trademark over vulture, the bird vulture. Court said, come on, man. Do you expect a consumer to differentiate between an eagle and a vulture? It is not distinctive. If it is not distinctive, it will lead to consumer confusion. That is the second standard. Lack of distinctiveness leads to consumer confusion. If the mark is not distinctive, it will confuse the consumer. So as I said before, the thrust of trademark protection is the consumer. So if the if the trademark office feels that a consumer will get confused between an eagle and a vulture, definitely will confused. Will some consumer check for whether it is vulture or eagle? No. So if it is not distinctive, it causes confusion, or if it indicates the quality of a product. Marayur Sarkara. What is the meaning? Marayur Sarkara. What is the meaning? Jaggery, Marayur Jaggery. Yeah.
Produced at Marayur.
Precisely. It explains. The name itself explains. A jaggery is produced at Marayur. It is not trademark. I'm not giving a trademark. I'm just giving examples. So that name per se explains. Or 50 grams of gold. It explains that the gold contains 50 grams. That's it. So if the name indicates a quality, you won't get a trademark. You also will not get a trademark if the name is so common among the group that it is not distinctive. For example, Xerox. What is the meaning of Xerox nowadays?
Making a photocopy?
Precisely. We always say that, please go and get a Xerox. But do you know that it was a company? Xerox was a company. But it lost its distinctiveness because people used it left and right for everything, for photocopying. Escalator was a company, trademark company. But what happened? Nowadays, anything which goes up and comes down, we call it as escalator. It lost its significance. It lost its distinctiveness because people started using it along with the product. Escalator was a company who made all these escalators. Xerox was a company who made photocopy machines. So through usages, people started linking the trademark with the product as alternatives. It lost its distinctiveness. In that case too, you will not get trademarks. Pashuvin Pal, you won't get. Right? So these are the standards in which to get trademarks. If these standards are met, then you will get a trademark. Now, rights of a trademark, I have not put in the slides precisely because I did not bore you with the rights. You have so many rights. Right to sell, right to use your marks, right to use your marks along with the designs, right to import your goods along with the marks. So all these are rights that you have been assigned with. I think it's almost 8 o'clock, and I can go on speaking regarding trademarks or IP because it's my domain. But I think this is the overall picture that I want to give on trademarks. So I'll stop it here. This is how trademarks is being granted. There are so much to talk, but I don't want to go into all those details. Trademark is something that I teach for 4 semesters. So in 1 hour, I can't cover all these things. But this is how trademarks comes into picture. Any questions that I can take at this point regarding what I have taught, or if you have any queries regarding your practical level questions or something like that, I can answer it. I'd be happy to answer it.
That was indeed an insightful lecture, sir.
Thank you, ma'am.
Now, the floor is open for discussion. If you have any queries, please ask or type in the chat box.
Yeah, I think Senthil Kumar has raised a hand. Yeah.
Very good evening, sir.
Good evening, sir.
Yeah, very nicely presented as a friendly way of lecture.
Thank you, sir.
I have a common doubts, not only for me, probably many of them, they have a doubts on this trademark, because one of the very important alarming one. Number one, KSRTC is owned by both the Kerala government and the Karnataka government.
Yeah.
Whenever you go to Kerala, there are also KSRTC. When you go to Bangalore, there are also KSRTC. And they have both the states, they have battle with this to trademark, right?
Yes.
And finally, Kerala government won the trademark, right? And now with the Kannada government, they have a lot of different names, but we cannot deny them because there's also Karnataka, there's also Kerala. We cannot change the name of the states, right? They have what you know, Rajahamsa, that is Yaraft, and some that is Sambaska, Nagara. There are many names. Even if you take Kerala government bus, only Kerala government bus. Take Tamil Nadu, only Tamil Nadu. AC bus, non-AC, that's all. But you go to Karnataka, lot of brand because of the issues are happening in the trademark, right?
Yes.
But how this government can claim that Kerala only can have this trademark for KSRTC? Number one.
Yes.
Number two. And take a Bangalore Iyengar bakery. This man, no one knows it. Take a Tamil Nadu, even go to a remote village. Too much of Bangalore Iyengar bakery. Nothing to do with Bangalore Iyengar. We don't know who is Bangalore Iyengar.
Yes.
That is a very complicated issue. Even a few months, I heard that a few years back, High Court or Supreme Court of Mumbai, they banned nearly 400 shops in Mumbai. You have to pay the royalty to the Bangalore Iyengar and all.
Correct.
But what happens to the remaining states of India? Number two.
Yes.
Number third question, you take a Rolls Royce. They never depend on the trademark of Rolls Royce. They always demand the consumer. Whether you should have the capacity or capability to maintain this vehicle. Even you take, we have a BMW, Benz, and all these the professors have all the cars. But I don't know any professors having a Rolls Royce in India. Only the corporate companies, film actors only have this Rolls Royce, right?
Correct.
But why this trademark known? Everybody knows what is a Rolls Royce trademark. But why they demand the consumer should have the capability or capacity to maintain the vehicle? And what is the role of the trademark here? Only these 3 questions, Professor. Thank you very much.
Thank you so much. Yeah. I'll take one by one. So, your first question was on KSRTC and KU, Karnataka bus. Yeah. Let me put this on record. As you were confused, when I was confused. I really need to understand what the hell was going on between Karnataka government and Kerala government. To be very frank, just because a judiciary, with all due respect, that I may not be sued for contempt of court, but still, just because there's a judgment Just because there is a issue that has been raised does not mean that that's correct. Let me put this on record. Almost 70% of the intellectual property rights judgments that has been delivered by the Indian courts, again with all due respect, are having immense number of flaws, hectic flaws, precisely because IPR is a new subject. Judiciary is not equipped to handle it. Again, with all due respect, and I pray that this recording shall not be gone, it should not be spread along. So, just because there was judgment doesn't mean it is correct. That's my first point. Now, coming to the issue of KSRTC and Karnataka, the point that was raised in the court of law was that the lawyer argued, person going from Kerala to Karnataka might get into the wrong bus. He might miss the bus because both buses connect KSRTC. This was claim. I'm not talking. This was one claim that they had. So the consumer confusion that was argued over there was that consumer can't differentiate two kinds of buses. One will take it to Kerala, one will take it to Karnataka. I'm not with that logic. To be very frank, I'm not justifying the logic, but this was one argument raised. Now, your question: how could Kerala government claim a protection? As per the Trademark Act, they can claim, because trademark primarily is a property protection. Property in the sense absolute protection, obviously with exceptions. That's true that the Act identifies. There are exceptions. But within that exceptions, it's a property. So the prior user is the question. Who used it first? Was it the Kerala or Karnataka? If it was Kerala who has used it first, then yes, Kerala can claim ownership because it is claimed that it is our property. Again, I put it on record, I am against it. But still, as per the law, if prior user has been using a mark for a long time, you will get protection because consumers have been used to seeing KSRTC as Kerala Road Transport Corporation rather than Karnataka. Karnataka came later. So that is one ground you can claim protection. So if it is your property, you will get protection because you are using it for a long time.
So here, sorry, Professor, here the evidence is most important, right?
Sorry?
The evidences are most important here to register trademark, right?
Precisely. Yes, definitely. Because I will link this to your second question on, I forgot, Iyengar Sweets, it was, right?
Yeah, sure, Iyengar Bakery.
So I will link this two issues together. KSRTC as Iyengar. Just like Iyengar, in Kerala, there was a case on Sharavana Bhavan. You would have heard it. Sharavana Bhavan is a very famous brand. We all say Sharavana Bhavan, but it is Sri Mu Sharavana Bhavan. It's a famous brand. You go to any veg hotel right now across Kerala, you will find two kinds of veg hotels predominantly. Either Sharavana Bhavan or Aryas. In fact, both these are trademarked items. The Aryas as well as Sri Mu Sharavana Bhavan. So the case was like this. The original Sri Mu Sharavana Bhavan was started by around 1970s by a common guy in Tamil Nadu, I believe. My memory is correct. It's in Tamil Nadu. He began there as a small shop. In 70s, he expanded in a local manner. In 90s, one big guy, a guy with business background, took up this name. He started left and right, Srimu Saranavan, in a very hi-fi manner, not simple manner, hi-fi manner. And another guy started a hotel called as Sharana Bhavan in Kerala. So this second party, who had chain of business, sued the third party in Kerala, saying that Sharavana Bhavan was our trademark. And this third party was very smart. You know what he did? He went to Tamil Nadu, searched Tamil Nadu for this original Srimu Saranavan guy. He produced evidence from 1970s. This guy was using Srimu Saranavan, and the second party, came 20 years later. So if at all any trademark needs to be granted, it should be to the first party, not this guy. Prior user. As I said in KSRTC, prior user. Evidence. And the second party, Srimu Saranavan, understood this is going to be an issue. So they withdrew the case. Because they will lose their trademarks if it is proved that some other guy was using it for a long time. So Iyengar case is the same scenario, because the Iyengar Sweets Act was in fact been there for a long time, and if anybody else is using that mark, even in small manner, it is violation, no doubt, because they have been in the business for a long time. So not only Bombay, if it is Kerala or Karnataka or Tamil Nadu or Andhra, anywhere it is, they may sue it, no doubt, under the Trademarks Act. But personally, I feel, why should they sue? Poor guys. They are not in competition. But yes, as per law, they have a right to sue it, no doubt. They are the prior users. They have a registered trademarks. They can sue. Come on. It's just a sweet. Why do you want to? If at all they are competing, then of course, definitely. But if not competing, let them have their own product. That's my viewpoint. Now, I forgot the third question. I'm sorry, I forgot the question. What was the third query?
And that is regarding the Rolls Royce, Doctor.
Yeah, exactly. If memory served, you were asking why Rolls Royce did not trademark. Was that the question, or?
Yeah. Rolls Royce everybody knows, but you take example of BMW, Benz. Anybody can buy the BMW, Benz. But Rolls Royce, worldwide knows that a uniqueness. The brand is already everybody knows in their mind. But why the demand the consumers? Whether you should have the capacity, capability. There are many Indian, because as a professors we cannot afford Rolls Royce, right?
Yeah.
But even anyone register for Rolls Royce, the demand, what is our capacity, what is our capability to maintain this and all, and what is the relationship between here copyright, the trademark, and the consumerism here?
Okay. Simple answer is no connection. The trademark, that's why in the beginning I said, for advertising purpose, trademark, yes, it is being used. But let me put it like this. I'll give you another example to substantiate this example or explain this example. I'm going to patents. You would have heard the company called as Pfizer. The Pfizer is a very famous MNC which works on medicines. In a YouTube interview, it's available online, the Pfizer CEO has openly stated that our goods, our medicines are prepared for the allied group, a certain medicine. I don't want to name the medicine, but that medicine is prepared for the allied group. who can afford that price. So we only make, and I'm not joking, this is what he said, we only make 100 numbers of medicines in India. 100 numbers. We only make 100 numbers. And that too, they don't have factory. They import from US. The reason? That will fetch them profit. That profit is enough for them. That the price of the medicine might be 3 lakh, 4 lakh or 5 lakh, but the allied group can purchase it, can afford it. That's economics, typical economics. You can make profit in 2 ways. One, produce more, distribute more. Price it low. Produce low, distribute low, price it high. This economics works in trademarks too. You don't want protection. Nobody can make an allied Rolls-Royce car like they do. They purchase it. They don't want a protection on trademark. The market takes care of themselves. It is a market that protects their investment. Even if somebody comes up, I don't think Rolls-Royce is going to go for a case if somebody comes up with an undergarment by the name Rolls-Royce. They're at least bothered. They don't want protection. They have a reputation in the market which is detached from IP. But that is a rare case, let me tell you. That's a rare case. Almost all the 90% of products that you see in the market are trademarked precisely because they want to protect the investment. But rarely, as you have correctly pointed out, Rolls-Royce is a typical example where it has no connection. It is trademark. I mean, it is protected as well-known trademarks. It can be protected as a registered trademark, but it is not dependent on the protection. The market takes care of that aspect. I hope I have answered your 3 questions. Is there any question?
Yeah, very interestingly processed. I have several questions, but I am leaving this place for other participants. Thank you very much, Doctor. Thank you.
Thank you, sir. Thank you, sir.
Any more questions? No, I guess.
So, formally thanking once again for the patient.
Sir, so now let's move on to the next session. Now I invite Dr. P. Venkateshwari, Associate Professor and Head, Department of Electronics, RVS College of Arts and Science, Sulur, Coimbatore, to deliver the vote of thanks. Ma'am, over to you.
Thank you, Ms. Jayashree. Thank you, Ms. Jayashree. I feel immensely happy to present the vote of thanks of today's session. I express my sincere thanks to our today's chief guest, Dr. Vishnu Shankar from University of IPR Studies. Really, it was a clear and wonderfully interactive session with examples starting from the trademark of a barbershop owner to a BMW and Benz car owner. We gained clear ideas about the trademarks, sir. Thank you once again. I would also thank all the organizing team members for this wonderful effort from the bottom of my heart. Thank you all.
Thank you. Thank you so much. Thank you so much.
This was indeed a fruitful session. Now it is the time for wrapping up the session. Hope to meet you all tomorrow evening, same time for the session of day 6. Thank you so much for your patient listening. Thank you all.
Thank you, sir. Thank you, sir.
Thank you.